I'm an immigrant. My parents grew up in Europe under Nazism, real Nazism, and then under domination by the Soviet Union. I'm Czech by background. What they experienced growing up during those terrible years of the late 30s, 40s, and 50s was part of the fabric of my life growing up. It was the subject of everyday dinner table conversation. And the first things that were eliminated were the right to free speech and the right to a fair and impartial hearing in the courts. So hi, I'm Marie Fiala. I'm a lawyer in the San Francisco Bay Area and retired as of the beginning of 2020 after many years practicing in big law firms. And as you know, Lauren, I've been representing you along with my co-counsel Andre in the case we brought against Patreon, challenging their decision to terminate your account.
First of all, Marie, thank you so much for joining me today. I really, really appreciate this and all of the help you have put forward in this arbitration against Patreon. And I guess the starting question would be, what got you involved in helping with this big tech case?
Well, Lauren, thank you for having me on your show. I retired at the beginning of 2020 after a career spent at big law doing litigation in large law firms. The firms I worked in were generally very liberal, and I had to remain very quiet about my political views. And I could never have taken on a case like this one as a pro bono case because the committees that made those decisions wouldn't have approved it. So once I retired, I wanted to keep doing legal work, but I wanted that to align with issues I was passionate about. And one of those has always been the First Amendment and freedom of speech. And I see so much happening now in the public arena, both government and private enterprise, that's threatening those First Amendment rights. So when I heard about your case through a network of conservative lawyers, I was just thrilled and hoping we could help you.
Mm-hmm. So what did Patreon do wrong here? Like when you heard about the case, what were the things that stood out to you?
Well, first of all, I believe strongly, based on what I've seen, that Patreon's deplatforming of you was politically motivated. They made up a rationale, manifest observable behavior for terminating your account. And contrary to notions of fairness and due process, they didn't tell you ahead of time. It was completely by ambush. They didn't give you a chance to respond to the reasons, the purported reasons for closing you down, and they didn't give you any way to appeal their decision. It was just done by fiat. We know now that they based the decision to terminate you on complaints from a left-wing group called Hope Not Hate.
Could be the other way around.
Could be the other way around, right? And they also based the decision on describing your conduct in a way that it was manifestly false and that was later proven to be false. They made no attempt to investigate whether they had a basis for believing what Hope Not Hate was telling them. So they made up this standard, manifest observable behavior, and what that says, what Patreon says is, well, we can look at what our users are doing outside of our platform, anywhere in your life. And if we see something that we think endangers life or creates a risk of safety, we can cut you off without notice because you're engaging in some behavior that's risky. Well, a professional race car driver, somebody who bungee jumps or skydives, even just driving day to day creates risks. Clearly, they use that rationale as a way of selectively and arbitrarily enforcing the manifest observable behavior standard.
Right. And just to jump in here real quick so people understand, the reason they terminated me, they said, was I was partaking in actions that could lead to loss of life. And what Maria is saying here is riding a motorcycle could lead to loss of life. Any of these things could lead to loss of life. There has to be more of an actual reason than that, which they didn't really give.
And even if you accepted what they said, and this was in connection with your activities with Defend Europe, which I know you've reported on, even if you accept that getting in the way of a ship that is engaging in human trafficking is dangerous, Greenpeace has been blockading ships for decades. They've been blockading ships based on wanting to stop nuclear testing and other activities. Nobody would dream of alleging that Greenpeace is doing something that violates this standard. So clearly it was being applied selectively.
Right, of course. And there were a lot of users on Patreon, for example, that were supporting Black Lives Matter, which, no matter your opinion on that, it is factually true that the BLM protests, particularly in 2020, led to massive loss of life. There were dozens of people that died in those protests. So not even supporting or engaging in behavior that could lead to loss of life. People were supporting behavior that did lead to loss of life and remain on the Patreon platform. So next, and I mean, this may be a more technical question, but why did we bring forth arbitration in the JAMS courts instead of in just the regular courts, I suppose?
Just to give a second of background, arbitration is basically a dispute resolution process that's done by a private company who gets paid for doing it. And in this case, the private company is called JAMS, Judicial Arbitration Mediation Service. Patreon put in its terms of use for every user on its platform that if they had a problem with Patreon or a legal issue, it had to be arbitrated, and it had to be arbitrated at JAMS, and you didn't have any recourse. It was forced. It was a forced arbitration, and it was on a take it or leave it basis. If you didn't want to accept that, you weren't going to be able to get on the platform. And so at the time, you had your issue with Patreon, the absolute only avenue we had for resolving that was to go to this specific private arbitration firm and bring an arbitration claim there. You were not allowed to go to the courts and have your claim decided by a judge and a jury.
And did you have confidence in this arbitration process when we were initially entering it, with both just having dealt with arbitrators before, the particular arbitration we were bringing forward? What were your thoughts about the success possibility?
Well, I want to start by saying that JAMS is a very well-known and highly respected firm. And in my prior career doing commercial disputes, I have litigated in front of JAMS and thought very highly of them. But this was not a commercial case. It's a case with a lot of political overtones and sensitivity. And especially since we were going to the JAMS offices here in the San Francisco Bay Area, we knew that there was going to be a real issue about whether we could find an arbitrator who was objective enough to hear the facts before prejudging the issue. So when you go to JAMS, you don't get to choose your arbitrator. They give you a list of 5 names, and each side privately kind of rank orders them and gives that ranking to JAMS from best to worst or worst to best, and then JAMS tells you who your arbitrator is going to be. So we had 5 names, at least a couple of people on that list based on their previous history, where they had worked and the kinds of cases they represented, were obviously going to be coming at this from a very, very liberal point of view. We hoped for the best, but we were aware that we were fighting an uphill battle even at that point, and that the chances of getting an arbitrator who was objective, let alone sympathetic to your issues with Patreon, were not great.
Yeah. That might be strange for people to hear, and this is a bit of a side note, but when a lot of people think, oh, you've been mistreated, something that, a contract was broken between you and another person, you can just take that to the courts and they'll deal with it objectively. But it almost sounds like you're saying it's a misconception that the courts are objective.
Well, I having been a lawyer in front, for many, many years, I've been in front of a lot of judges who I think were fair and objective. But here in the Bay Area, and I guess many other places now, the whole environment is so steeped in these, very progressive, very left-wing views. It just becomes the water that the fish swim in. They don't know it's wet. Everybody, judges and juries, they are so steeped in these attitudes of, anyone who's conservative is literally Hitler or Nazis. And the only way to think about issues is from the progressive perspective, that I think even the most well-meaning judges are influenced by that. And they're also, I think people are also afraid that if they become affiliated in the public mind with ruling in favor of a conservative point of view or on a conservative on an issue that favors conservatives, that they are themselves going to be subject to criticism or even attacks. This atmosphere has been going on in the Bay Area for a long time now. Even 10 years ago, Silicon Valley executives were getting fired. Chief executive officers were getting fired because they had made a political contribution to a conservative cause or conservative candidate. So, I think it's very hard in this milieu to get a fair hearing if you have a conservative perspective.
Right. So in some cases, it's not even deliberate. It's just that's how everyone thinks. And they almost would think that's objective. That's just how you're supposed to decide things.
It's groupthink. Yeah.
That's crazy. Now, some people may be listening to this and thinking, well, Lauren, Marie, we already saw attempts to sue or bring arbitration against Patreon, and they were dismissed. So how is your case any different? Are you just making complaints that already happened with Milo Yiannopoulos and Owen Benjamin? Like, what is unique or different about our arbitration?
Well, you're right. We looked closely at the Owen and Milo arbitrations, and as you said, Lauren, they had breach of contract claims, and the arbitrators in both of those cases dismissed their claims just based on the initial pleadings without allowing discovery or taking evidence. So we wanted to do something different in addition to that. And I actually think that this, despite the sad outcome in your case, that this is something lawyers should think about in the future if they are bringing claims like this against online platforms. We brought a claim that alleged that Patreon breached a duty of reasonable care in deciding to terminate your account without giving you notice, without hearing your views, and without giving you an opportunity to appeal. This legal principle, duty of reasonable care, is actually, as a matter of law, implied in every contract. And there's recent case law here in the federal courts in California that says that yes, that was a case involving Facebook, but it says yes, Facebook's terms of service include this duty to exercise reasonable care. So we alleged that the actions Patreon took breached that duty, separate and apart from whether there was a breach of the contract. The key difference is that that is a fact-based claim rather than a purely legal claim. Reasonable is a factual term. And when you have a fact-based claim, the arbitrator or judge can't dismiss that without allowing the parties to take evidence and present facts. So the reasonable care claim is a claim that if the arbitration had gone forward, should not have been dismissed, should have allowed us to take discovery from Patreon. Now, how much discovery we got, that would have been up to the arbitrator, but we were entitled to take at least some. So we could have asked Patreon for their emails, texts, instant messages, documents, internal information showing why they decided to terminate your account. We could have asked them for communications with Hope Not Hate. We could have asked to take Jack Conte's deposition. He got very personally involved, as your listeners know, in defending their decision to deplatform you. So we would have asked to take his deposition. Now, it wasn't a certainty that the arbitrator would have given us all of that discovery, but it would have been, as a matter of law, very, very difficult for this claim to be dismissed just out of the box without any discovery. We should have been able to take discovery, and we should have eventually been able to have an evidentiary hearing where we presented our case about what was reasonable care, and Patreon defended itself. But because of the way JAMS handled your particular arbitration and the consumer issue, which I know we're about to get to, we weren't able to continue. But I do think that this is a fruitful avenue down the road for lawyers who are thinking about bringing these types of claims, and I would encourage that.
Yeah, and I would have been so interested to see that info too. For some people have already heard this without any context, but right after or not too long after I got banned from Patreon, I met with Hope Not Hate to confront them about that, because they publicly claimed that they had lobbied Patreon to get me removed. And Patreon were like, no, we don't remove accounts just because of social pressure or lobbying. I met with them in a bar. I think it was like December 2017 or something like that. And they told me to my face, yes, we were the one who got your account removed from Patreon. We were on the phone with them all the time. And this is directly what Hope Not Hate told me. And I gave you guys this information. I would have loved to pursue that further. Man, I would have been so curious, because that seems like that would have been huge to discover. But yeah, we never got to do that because of consumer rules, the decision made around that. Can you explain what happened with me being ruled as a corporation? Why was it important that we be under the consumer rules rather than me being ruled as a corporation in this arbitration?
Well, because arbitration is private, it's expensive. Arbitrators at JAMS typically charge somewhere between $3,000, $4,000, $5,000 for a half a day of work. And for many arbitrators, if they work for an hour, they have terms in their contract that say our minimum billing block is a half a day. So even if it's an hour, you still pay $3,000, $4,000, $5,000. The dollars add up really fast. So if you think about being in the position of a Patreon user, you're forced to go to JAMS, but if you go to JAMS, you can't afford to pay the fees. So JAMS has a set of rules, the consumer minimum standards, and they actually reflect state law. State law says you can't have a private arbitration firm that doesn't give these protections to consumers. Otherwise, it's very one-sided. You have, small user on the one hand, you have a big company like Patreon or Facebook or Google on the other hand, and you're not going to be able to proceed. So the consumer minimum standards basically say that in a dispute between yourself and a big company, other than a very small initial filing fee, the company is going to have to pay the arbitration fees, the many, many thousands of dollars. Not only do the JAMS rules say that, but importantly, Patreon's own terms of use, which is the contract between Patreon and its users. At the time you signed up, Lauren, their contract said, we will follow the JAMS consumer arbitration minimum standards. Why did they say that? Because they wanted to reassure people who, pardon my French, who signed up for their services that they weren't going to get screwed if there was an issue. If Patreon ended up not paying you monies from donors or overcharging you or whatever the dispute was, they wanted to reassure users that they were actually going to have a realistic way to raise that dispute without having to pay all that money for the arbitration fees. You mentioned Owen, Benjamin, and Milo earlier. They brought their disputes under the same contract you did. And in each case, Patreon started thinking, despite the fact that they had put this language in their contract, they started thinking better of it because they were potentially having to pay many thousands of dollars in arbitration fees for claims brought against them. So they started bringing motions in these other arbitrations saying to JAMS, Well, the provision in the contract doesn't really mean what it says, and you should hold that these people are not consumers and have to pay their own way. And for Owen Benjamin and Milo and others, JAMS disagreed with Patreon, said yes, they're consumers, they are consumers of Patreon's services, and they applied the consumer rules, which meant Patreon has to pay. Patreon bought the same motion in your case. In fact, their brief was almost word for word a copy of what they brought in the Owen case and the Milo case. But stunningly, and for the first time, the arbitrator and JAMS decided that they would not treat you as a consumer, that in order to go ahead with your claim, you had to pay half of the legal fees, the arbitration fees involved. And as I said, that could have amounted to an awful lot of money. Many things that are really striking about that decision, but the one, just as a technical legal matter, JAMS is looking at the exact same contract, the exact same language, people who are similarly situated. If anything, at the time, Owen Benjamin and Milo Yiannopoulos were commercially much more successful than you were. And JAMS is applying the same contract to similarly situated people in a 180-degree opposite manner, without saying anything about the inconsistency or why they treated those folks as consumers, but decided that you shouldn't be a consumer.
So I have a random legal question here because I've been looking into it a bit. Now, after this case, I've kind of gotten interested in the legal system. What happened to precedent there?
Well, as a technical matter, for legal reasons that I won't go into, JAM's own decisions on the Owen Benjamin and Milo Yiannopoulos arbitrations isn't binding legal precedent in the way that if you were in federal court, you have to follow what the Ninth Circuit says. But we pointed those decisions out to JAMS and said, fundamental fairness and equitable treatment of similarly situated people means that you should reach the same conclusion here that you yourselves did in these previous cases, and they ignored that. They gave no reason in their decision for why they were inconsistent with the decisions in the previous arbitrations.
What's your best guess at what happened there? Like how does this even, how did you and Andre mentally even reason this, trying to grapple with such a bizarre decision?
It's really hard to understand as a lawyer, and frankly, I found the decision shocking. First of all, you would expect JAMS to be internally consistent. And it wasn't a question of one arbitrator doing one thing and another individual arbitrator doing a different thing. All of these decisions went up to a central committee at JAMS that made the ultimate decision. And it decided one way in the past and it decided differently. I don't know what was going on inside people's heads. The way it worked is the arbitrator wrote a long report. That went to the central committee. His report was written in a way that suggested that you should not be treated as a consumer, and that's what the committee basically rubber stamped. But there were certainly elements in the way the arbitrator described your case. For example, he went out of his way to characterize you as an alt-right journalist, which suggested to me that was going to, at a minimum, be a heavy thumb on the scale when this was finally decided by the Central National Arbitration Committee. I mean, there was no reason to go out of his way to describe you that way. It's a very inflammatory and prejudicial term. It's also untrue. And I think, as you've said, previously, Lauren, in your videos, would you go out of your way to describe someone based on their sexual history or their gender orientation or any other characteristic about them that somebody else might find damaging or prejudicial. No, you should focus on the issue that's in front of you. And there was no reason for the arbitrator to go out of his way to characterize you. And again, it's the Bay Area, and the National Arbitration Committee sits in San Francisco. So I expect that the way you were described and the way your claim was described had an influence on the way some of them at least thought. I think also that they probably didn't pay attention to how different your claim was from those brought by Owen Benjamin, Milo, other Patreon users. My guess is that somebody thought, well, this is just another cookie cutter claim, just like those claims. We've dismissed those claims. Why should we be meticulous about how we, handle Miss Southern's claim? It's just going to get dismissed. I mean, I'm speculating. I don't know what was in people's minds.
Well, now a lot of people have stated on the last video I published, well, you can raise the level of concern here. You can make a complaint, Lauren. I really hope this is retried or something. We did try to put in a formal complaint describing the problems with this decision. That didn't go over so well. So I think the question to you there is why. Can you explain to people why it is so difficult to bring forward complaints about arbitrators' decisions in the legal system?
Well, we did ask internally at JAMS for reconsideration. We made a very strong case, and the same committee just denied it. Arbitrations, both in California and across the country generally, are given a lot of deference in statutes and by the courts. It is very, very hard to get an arbitration decision challenged or overturned in the courts. The courts overwhelmingly approve and rubber stamp arbitration decisions. There are only limited reasons why an arbitration decision can be challenged. You basically have to show things like there was fraud or corruption on the part of the arbitrator, or substantial misconduct of other kinds, or a few other reasons, but they're very narrow, very limited. And other than that, you have no opportunity to go to court and say this was wrong, we were denied due process. It's really a legal catch-22. Patreon says, and many other large companies say, you have to go to arbitration, you can't go to court. And now they're saying, we're going to force you into arbitration, and we're going to make you pay half of the costs, which as an individual, most individuals can't afford. And then the end result is that you have no legal remedy whatsoever for your claim and for however badly you've been treated by the party on the other side. And I think that's a serious concern, implicating important constitutional rights like due process and the right to a hearing. Unfortunately, the way this contract was set up, we really didn't have any alternative but to fight as hard as we could at JAMS. And going to court just wasn't a realistic option.
Now, this isn't the first case I or probably you have heard of where there's been questions of bias going on, or just kind of weird decisions that seem inexplainable. And for this case specifically, and others like it, I think the biggest question and the heaviest question we're going to talk about today is, what does this mean for the American legal system and the direction that it's headed in?
Well, I mentioned at the beginning that I'm really passionate about First Amendment rights and free speech in particular. And if I can just digress for a second, I'm an immigrant. My parents grew up in Europe under Nazism, real Nazism, and then under domination by the Soviet Union. I'm Czech by background. What they experienced growing up during those terrible years of the late 30s, 40s, and 50s was part of the fabric of my life growing up. It was the subject of everyday dinner table conversation. And the first things that were eliminated were the right to free speech and the right to a fair and impartial hearing in the courts. And in the current climate, it's terrifying to me to see those fundamental constitutional rights being eroded away, often by large and powerful private companies, not even by the government. Especially here, companies that are based in Silicon Valley. This has been going on for 10 years or more. People being fired, removed from boards because they donated money, a fundamental First Amendment right, to a political candidate or issue that's not sufficiently progressive. Here's the problem. Those online companies, private platforms, Patreon, Facebook, Twitter, they're not bound by constitutional limits on their behavior. The First Amendment doesn't apply to a private company, with certain exceptions, but most of the time, private companies can act however they choose. The government can't violate your First Amendment rights, but that doesn't protect you when you're dealing with a private actor on the other side. These companies control vast amounts of speech. They really are, in my view now, dominant ways of communicating. Yes, you could write a letter and put a stamp on it and give it to the post office, but people communicate and transact business on these huge online platforms and don't realize that when they are dealing with these parties, they have no constitutional rights. You don't have a right to free speech. You don't have a right to freedom of association. You don't have a right to due process. And so we have a gap in our legal system right now for how to protect people's rights when they're dealing with censorship by private enterprise. Other countries have started recognizing this issue and dealing with it. There's a recent decision out of Germany against Facebook saying that Facebook wasn't entitled to delete users' posts and block her accounts because they didn't give her advance notice about the removal, and they didn't give her a chance to express her views, and they didn't give her a chance to appeal. Exactly the same conduct that Patreon did here. I know that there are movements in a number of states in the United States. Texas just passed a law that was signed, I think it might have been signed by the governor yesterday or today, that prohibits online platforms from banning users based on the political content of their speech. And I know that Florida passed a similar law, and it's being considered in a couple of other states. And I know that for a certainty, these laws are going to be challenged in the courts, and we don't know where it will end up. But I think one way to proceed is for the states to try to fill this gap in enforcement by passing laws that will protect users from censorship purely based on the content of their speech. Now, I don't know how it's going to turn out in the courts. It may well end up in the Supreme Court ultimately. But it's one avenue for looking for solutions, because I don't think we can expect the federal government to do anything to resolve this problem.
Yeah, this is a big question, especially now where, with lockdowns, the public sphere is no longer walking into the street and the police can't arrest you for having your free speech. The public sphere is online. It's the internet. That is where we have our discourse and talk about our politics, who we're going to vote for, what politicians are doing, what crimes they're committing, the things people need to know before voting in elections. And that there, like you said, there isn't that constitutional rights there. There isn't that right to free speech. And that's terrifying as these corporations gain more and more power. And sometimes it's difficult for Republicans to understand, I feel, that yes, corporations can be the problem, not just the government, especially if they've gotten to a point where it seems they have more powers than the government in some cases. They can literally censor the president. So I guess the last question I would pose to you is, what happens if we don't make change here? And what would be a positive kind of uplifting message that you can give, or encouragement you can give people in how they can challenge this descent of what seems like the fall of the American legal system, slowly but surely?
Well, I wish I had a very positive, uplifting message. When I look at what's happening against, my personal background, I see warning signs everywhere, and I don't see anybody paying attention to them. I honestly don't understand why people who have more left-leaning, more progressive political views don't understand the same risk. I mean, 40 or 50 years ago, the ACLU sued successfully to representing a group of actual Nazis, uniforms, swastikas and all, to allow a group of Nazis to mount a parade and a demonstration in a little town called Skokie, Illinois. And at that time, Skokie was at least half Jewish, and most of the residents in Skokie were actually Holocaust survivors, which is why the Nazis wanted to march there. The ACLU went to court in a landmark First Amendment case to say, Skokie, the town of Skokie, you can't prevent this march. That ACLU was, our grandfather's ACLU. We don't have that anymore today. But I would like people of all political persuasions to think about where this leads. At some point down the road, once half of the population's political views are no longer allowed to be heard, the whole basis for our governance, for free and fair elections, collapses. And, somebody said about the Nazis in World War II, I didn't speak up when they came for the priests. I didn't speak up when they came for the homosexuals. I didn't speak up when they came for the Jews. And when they came for me, there was nobody left to speak. We are in that. We are in danger of seeing that happen here. I think we are very far down a slippery slope. And I just wish people in all parts of the political spectrum would wake up and say, this isn't America. And we're all Americans. And just because I disagree with you doesn't mean you shouldn't be heard. I may reject your ideas based on disagreeing with the merits, but I'm going to allow you to speak. And I guess the message is, wake up. Wake up state legislatures, wake up courts, wake up people of goodwill on all parts of the political spectrum. See where this is going and stop.
Thank you so much, Marie. You've always, even in our private conversations, you have this insight that I think is so incredible, this perspective from two worlds. One, your family history, and the other, this America that you have loved and fought for, that free speech, these values. That was everything. The reason your family fled, I assume, was to be in a place with democratic values and right to a fair trial, elections, free speech. And it's really beautiful to see you fighting to retain that, given your history. And I really appreciate you helping me out with this case, regardless of the outcome. And I know you will continue to fight.
Well, thank you, Lauren. I wish we could have gotten a better result for you, but I know with people like you speaking out, that's really the basis for hope.
Thanks, Marie. All right. Thank you for watching, everyone. And I will see you next time.